Good day, Crime Talk aficionados. We have another great show for you. First, newly released filings help outline the case against Bryan Kohberger. An old juror in the Karen Read case speaks out, and frankly, I don't think it helps Karen Read. Luigi Mangione writes a letter to a fan. Don't nag your husband, all right? Good advice for the day. First firing squad in 15 years. We talked a little bit about that yesterday. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. I was looking at some of the stats for the podcast itself, not just YouTube. I don't know how many whatever millions we've got over there, but the podcast is like 2.3 million downloads. Not bad. Not bad for a guy that started this not knowing what the heck he was doing. All right. Before we get to the docket, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States. And you'll have a report emailed to you literally while you wait. And that report can be updated if you desire as new information becomes available. And that report is going to have information regarding the person that you're searching, their social media presence. Do they own property? Where do they live? What kind of car do they drive? Do they have a criminal history? Do they have debts, judgments? Do they have to, register on one of those public registries we hear so much about? All those types of things that you want to know about somebody coming into your life. I'm telling you, a Google search just doesn't do it anymore. Listen, you're going to have searches from literally hundreds of thousands of databases here in the United States, all wrapped up, packaged nice for you so you can take a look at it and see what is there. It literally could save your life or somebody else's life someday by knowing who's coming into your life and maybe deciding if somebody needs to exit your life. Go to crimetalksearch.com today. All right. And one more thing. That's right. The BattlBox has arrived. For those new to the program, this is not a sponsorship thing. It's just something signed up for, a couple years ago. And they thought, hey, maybe people would like to see the stuff that comes in the BattlBox. And it's been driving me crazy because it arrived literally right about 5 p.m. last night and I wanted to open it. But no, I said, I promised to show it all to you first. So we will break out the official Crime Talk K-Bar and unpackage this at the end of the show. All right, let's go ahead and get to the docket for Friday, March 7th, 2025. So as everybody knows, Kayla Gonzalez, her best friend, Madison Mogan, roommates Zana Kernodle, and Kernodle's boyfriend, Ethan Chapin, were all stabbed to death inside their off-campus student home. And the three women shared with their two other roommates there in Moscow, Idaho, back in November of 2022. Now, Bryan Kohberger, obviously, given the presumption of innocence, a PhD criminology student, has been charged with their murders and one count of burglary, and ultimately faces the death penalty if he is convicted, and his trial that gets started here in August. Well, guess what? This new judge, I like him. He is unsealing things, and he is of the mindset that this should not be kept from the public, and I thank the judge for doing this, okay? The public has a right to know. Frankly, it's not a lot of stuff we didn't know, but it helps us give just a little more context, and it's what the prosecution believes is the truth, or what they believe is the truth. And now the defense has an opportunity to challenge it. All right. Now, I think, and like I said, I'm a defense attorney. All right. I like when the underdog, which is the defendant, wins. All right. But I'm also a realist, right? Everybody thinks, oh, you're a defense attorney. You just drank the Kool-Aid, and everybody charged with the crime is, not guilty. Not the case at all. As an attorney, you have an ethical obligation to advise your client, right? And to meet their goals. And sometimes that's mitigation, which means the least amount of punishment for what they may have been accused of doing, which they have to plead guilty to, right? So you're constantly evaluating all the facts that are coming in. And you have to be realistic to the client. And you have to be able to say, that's a bad fact, and I'm not sure how to get around it, right? As the old saying goes here at the Reich Law Firm, why are we going to let the facts get in the way of a good defense? Well, we say that in jest because you cannot ignore the facts, all right? So these new filings reveal for the first time the panicked text messages sent by the surviving roommates Dylan Mortensen and Bethany Funk moments after the slaying, as well as the chaotic 911 call transcript around 8 hours later. Now, in the early morning hours of November 13, Mortensen came face to face with the masked intruder inside the home and made a series of calls and texts to her roommates. Only Funk answered. The others didn't because they were dead. At around 4 a.m. on November 13th, 2022, Mortensen, whose bedroom was on the second floor, was awoken by noise in the 3-story home and heard a voice say, "There's someone here," according to the court documents. She also heard what sounded like whimpering coming from Kernodle's room and a man's voice saying, "It's okay, I'm going to help you." Mortensen told investigators she had opened her door and peeked outside 3 times. The third time, she said she saw a masked man with bushy eyebrows and dressed in black walk past her door and head towards the sliding back doors of the home. In the unsealed court filings, it has been revealed that a terrified Mortensen then called her slain roommates Gonsalves, Mogan, and Kernodle, as well as Funk, between 4:19 a.m. and 4:21 a.m., desperately trying to find out what was going on. All the calls went unanswered. And between 4:22 and 4:24 a.m., Mortensen and Funk then exchanged a series of texts about her sighting of the man. "No one is answering," Morton texted Funk. "I'm really confused right now," she wrote. Mortensen then sent 2 unanswered texts to Gonsalves. "Kaylee, what's going on?" She got no reply. In a back and forth with Funk, the 2 younger students are seen trying to piece together what was going on inside their home. "Yeah, dude, WTF," Funk texted. "Zaina was wearing all black," she added in another message. Mortensen texted Funk, "I'm freaking out right now." "No, it's like ski masks almost," she added in an apparent reference to the man that she had seen inside their home. Now, when Funk responded, "STFU," and then actually, Mortensen added, like he had something over his head and a little mouth. "I'm not kidding." And "oh, I'm freaked out," Mortensen said. Funk agreed, "So am I." Mortensen then said her phone was about to die, and Funk urged her to run downstairs to her bedroom on the 1st floor. "Come to my room. Run. Down here." After the text exchange, Mortensen then tried calling Chapin, Gonsalves, and Kernodle another time. She also sent a text message to Gonsalves at 4:32 saying, "Please answer." In a separate court filing, it was revealed that Mortensen did go down to Funk's room, and the 2 young women ultimately fell asleep. The following morning, starting at 1:23 a.m., Mortensen then sent texts to their other roommates. "Please answer," she texted Gonsalves. "Are you up?" she texted Mogan. And to Gonsalves, "Are you up?" Mortensen then had a text exchange with her father at 11:50, called a neighbor known as EA, the documents show, and minutes later, a 911 call was placed from Funk's cell phone. The distressing transcript of the 911 call, also released for the first time, shows that the call was made after an individual known as HJ had found Kernodle's body inside the home. In the call, the caller described the 20-year-old as being passed out and not waking up. "Hi, something has happened. Something happened in our house. We don't know what," the call begins. The dispatcher is told that Kernodle is passed out, was drunk last night, and is not waking up. When asked if she is breathing, the dispatcher is told no. Kernodle is not mentioned by name, and there's no mention of the other 3 victims, suggesting that they have not yet been found. There's also no mention of the bloody, violent scene. The caller also mentions Mortensen's signing of a man inside the home hours earlier. "Oh, and they say some man was in the house late last night," a voice says. The call is disjointed as the phone is passed between EA, HJ, Funk, and Mortensen during the ordeal. Throughout the call, the dispatcher hears constant heaving, breathing, and crying. Now, towards the end of the call, a different voice, believed to be that of an officer, says, "I think we've got a homicide." Now, the release of these details comes as both the prosecution and the defense continue to file a flurry of court filings in this case. Now, obviously, Mr. Kohberger is due in court on April 1st. Now, here's what I want to do. This is new, and we want to make sure we get it as accurate as possible. All right. And what this information was released in was a motion. It's a motion to eliminate regarding text messages for testimony. Now, remember, a motion to eliminate is asking the judge to make some pretrial evidentiary rulings on some cases. And in this particular case, the prosecution wants to introduce these series of text messages between the roommates. Now, you'd say, well, Scott, I've listened to Crime Talk enough to know that's an out-of-court statement being offered for the truth of the matter asserted. That is hearsay. And yes, you are correct. And the prosecution knows that it's hearsay, unless, of course, there is an exception. And there is an exception called a present sense impression, basically where somebody's outlining what's going on at that particular time. Kind of gives some reliability to it. There's no need to fabricate, lie. Nobody changed it, anything along those lines. Additionally, it could be an excited utterance. If something's going on and you react, and once again, you don't have time to think about it or change it, it can come in. Now, do they really need these text messages? Not really, because these young ladies are going to come and testify. All right. And they could say, what did you do? All right. And did you send a text message to your roommates? Yes. What did you say? I said, are you up? What time did that take place? I don't recall. Would it refresh your recollection if you were to see a copy of your text messages sent that night retrieved from your cell phone? Why, yes, it would. Well, why don't you take a look at this text message and see if that refreshes your memory? Okay. You've looked at it. Turn it over. What time did that call take place? At 4:20 a.m. So they get it in. Why does the prosecution want it in? It corroborates what the witnesses are going to say. Obviously, it's very impactful. People understand. People are texting at that particular moment. So let's quickly go through the key points. The state of Idaho respectfully moves this court for an order in limine, allowing the state to admit the text messages of DM on November 13th and the testimony from DM and BF regarding their conversations with each other on November 13th. The phones were discovered on the hard drive of a DM phone extraction provided on April 5th, 2023 in State's Exhibit 18 in the grand jury. Then they go through the standard of admissibility. In general, testimony is hearsay excludable under Rule 802. However, there are exceptions. Two firmly rooted exceptions are 803.1, present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. Like it's a memo to file. Idaho Rules of Evidence 803.2, excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress or excitement that caused it. Okay, there you go. That's what they're trying to get the documents in under. And here's the other thing is these young ladies will testify, and therefore they will be able to corroborate that these text message exchanges went from each other. Anyway, argument. DM's phone records contained in Exhibit S1 from November 13th, 2022, and BF's testimony contained in Exhibit S2 as to what DM told her should be allowed at trial. In the case of Barr, starting on November 13th at 2:10 and 29 seconds, DM sends a text message to EG, the Uber driver, to inquire if he is driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of the matter asserted. Instead, it will only be offered to show a timeline for the night. DM was awake and texting at 2:10:29 from 4:19:07 to 4:21:50. DM attempts to call BF, Zaina Kernodle, Kaylee Gonzalez, and Madison Mogan. All calls were unanswered. The records of these calls are not hearsay as they each do not meet the definition of a statement, oral assertion, written assertion, or nonverbal conduct intended as an assertion under 801. Like I said, we talk about this all the time. You got to get the evidence in the record, and that's what they're trying to do. 4:22 to 4:24, DM and BF send the following text messages. DM to BF, no one is answering. DM to BF, I'm really confused right now. DM to Gonsalves, Kaylee. DM to Gonsalves, what's going on? BF to DM, yeah dude, WTF. BF to DM, Zaina was wearing all black. DM to BF, I'm freaking out right now. DM to BF, no, it's like ski masks almost. BF to DM, STFU. BF to DM, actually, DM to BF, like he had something over his head and a little ND mouth. DM to BF. BF, I'm not kidding. I'm so freaked out. BF to DM, so am I. DM to BF, my phone is going to die. F. BF to DM, come to my room. BF to DM, run. BF to DM, down here. All of the above declarations are present sense impressions and excited utterance. This is supported by DM's grand jury testimony, where she indicates she just witnessed a startling event, i.e., heard noises in residence and saw an unknown male in the residence. The declarations indicate both BF and DM are trying to make sense of the startling event contemporaneously or immediately following the startling event, i.e., no time for reflection or fabrication. That gives the reliability aspect to the statements. See DM's grand jury testimony attached. At 4:24:39, DM calls Ethan Chapin. Call unanswered. The phone record, like the other records of calls, is not a statement pursuant to 801A. DM and BF continue to text. At 4:24, DM texts BF, I'm so scared right now. BF responds, yeah, I know, but it's better than being alone. Again, both statements are admissible as present sense impressions and excited utterance. 4:27, DM calls Gonsalves. Calls unanswered. These are not statements. At 4:32:57, DM sends a text message to Gonsalves stating, please answer. The statement is a present sense impression and excited utterance. The next morning, DM sends the following text messages starting at 10:23:23. DM to Gonsalves, please answer. DM to Mogan, are you up? DM to Gonsalves, are you up? These text messages are not hearsay because they will not be introduced for the truth of the matter asserted. Even if deemed hearsay, they are allowable as present sense impressions, and they reflect a consistency and continuation of DM's text messages from the night before. And when they say it's not being offered for the truth of the matter asserted, that's one of the rules that you try to learn as a DA to get around a hearsay objection. Well, it's not being offered for the truth of the matter asserted. The defense says, well, if it's not being offered for the truth of the matter asserted, why is it relevant? Well, then the defense and them say, well, it's a present sense impression, Your Honor, simply to state that a call went in and you can give a limiting instruction to the jury. All right. At 11:39, DM has text exchange with her father. These statements are not hearsay and they will not be introduced for the truth of the matter asserted. Instead, they show a timeline for the morning. At 11:55, DM receives a text message from Jay stating, bro. This text message will not be introduced for the truth of the matter asserted. At 11:50, DM calls EA. This phone record is not a statement pursuant to 801. DM receives text messages from Jay at 11:51:01 and a vandal alert at 1:04:01. These texts are not hearsay because they will not be introduced for the truth of the matter asserted. DM and BF's testimony. The state anticipates that both DM and BF will testify at trial. The state intends to ask each witness about the statements made to them on November 13th, 2022, and this testimony should substantially replicate the testimony they provided at the grand jury proceedings. The state submits that the statements from both DM and BF to each other are allowable hearsay because they are present sense impressions and excited utterances. And obviously what the person testifies to as to what they said is not hearsay because they're testifying to it in court. And the other person, it's not being offered for the truth of the matter asserted, but the impact that it had on the listener. Did you receive a text from DM? I did. What was it about? What was your response? Well, I was freaked out and I sent this text message. The long way say really the only way that the defense could try to keep this out, I believe, is if they say it is cumulative under Rule 403. Because Judge, we heard him testify. What do we need to have this for? It's all coming in. Trust me on this one, ladies and gentlemen. It's coming in. Anyway, they also note, hey, by the way, Judge, the judge has previously ruled that the text messages and statements of DM to BF are present sense impressions and excited utterance, holding both the text messages and the testimony of BF as to what DM told her were admissible as an exception to the hearsay rule. So there you go. We got that. All right. Then the other issue is the state's motion to eliminate regarding self-authenticating records. Now, this is really boring stuff, ladies and gentlemen, but it helps once again to show that evidence is coming in as it relates to Bryan Kohberger, right? So what happens under self-authenticating records? 8036. All right. Records of regularly conducted activity. That's a business record exception. It's like your bank. Okay. Your bank has a duty to maintain this information and maintain the accuracy of it, right? They have a duty to do that. So it's a business record maintained in the regular course of business. And it's part of the regular practice to maintain these records, right? It's kind of like cell phone records. So they introduce these records, and then they say, oh, there's also some public records that are, once again, like a business record, but from a government organization. And there's a certain amount of reliability because they're in the duty of keeping track of this. So what do we have, right? Well, we've got video from the Albertsons in Clarkson, Washington. Some video surveillance, Amazon financial and user records for Bryan Kohberger. That's going to be the key one, ladies and gentlemen. Mark this down, tag this. It's going to be huge, in my humble opinion. AT&T phone records for Bryan Kohberger. The Bagel Shop video surveillance from November 13th, 2022. Bank of America records for BF and Zaina Kernodle. Banner Bank banking records for Ethan Chapin. Cafe Arista video surveillance from November 13th, 2022. Corner Club video surveillance from November 12th through 13th of 2022. Corner Club financial transactions receipts for November 13th. Costco surveillance video in Clarkson, Washington. The Sal student records regarding Bryan Kohberger. Dick's Sporting Goods records for sale for Bryan Kohberger. Discover financial records for Kaylee Gonzalez. DoorDash records for Zaina Kernodle and Ethan Chapin. Early warning records. Elon financial records for Kaylee Gonzalez, ENS services, Farmers Insurance surveillance video, November 13th, Floyd's Cannabis Company surveillance on November 13th, Forrest Dax financial records for Bryan Kohberger, Grub Truck video surveillance video on November 13th, Harbor Freight business and surveillance records, Idaho Central Credit Union bank records for Madison Mogan, Indian Mountain Lake surveillance and records, Joanne Fabrics financial records, Latah County Sheriff's Office Deputy Darren Duke's body cam video, Latah County Sheriff's Office citation issued August 21 to Kohberger, Marshall's financial records for Bryan Kohberger, National Weather Service records for November 12th and 13th. Probably has something to do with it was overcast and cloudy that night and whether you'd have a good look at the stars, I would imagine. National Weather Service, we talked about that. Numeric bank records for Kaylee Gonzalez. PayPal Venmo records. PNC bank records for Bryan Kohberger. Penn Teledata records. Pennsylvania State Employee Credit Union for Bryan Kohberger. Petco financial records for Kaylee Gonzalez. Rite Aid financial records. Ross financial records. Sunset Mart in Idaho. Sunset Mart on November 13th. Target financial records. TikTok user records for Zaina Kernodle. TJX financial records for DM. T-Mobile records for Kaylee Gonzalez, DM. UMPQUA bank records, DM. Under Armour transactions for Bryan Kohberger. U.S. Chef Store, Clarkson, Washington video surveillance. Chef Store, sharp objects maybe? Who knows? Anyway, Alta financial records, Verizon phone records, Walmart surveillance and financial transactions for Bryan Kohberger, Washington Department of Motor Vehicles video surveillance, Washington Trust records, Wells Fargo banks for Madison Mogan, Winco financial records for Bryan Kohberger, Winco financial records and video surveillance, Kaylee Gonzalez, Madison Mogan's, and Zaina Kernodle's, looks like hard drive, and then Washington State University video surveillance, and the Washington State University parking records. Anyway, then they go on to say there's trustworthiness as of these records. There's copies of public records, and they're basically self-authenticating. So it gives you an idea of what is coming in. Those purchases. Telling you, the video today is absolutely amazing. And I'm sure it's going to show and track everything. It's amazing what people don't know. Like literally, if you went in and used a card at, say, a Target, they can literally go back and get the video years earlier and say, oh, you were in line 16. This was the person checking you out. It is amazing, the technology as it relates today, and they can track just about anything. Then the motion limiter regarding the 911 call. We kind of went through the 911 call. We won't go through it in its entirety, but it's the same type of situation. It was a present sense impression. HJ located the unresponsive body of Zaina Kernodle and informed BF and DM to call 911. EA was present at the time. All declarants personally perceived the event, i.e. Kernodle unresponsive. The majority of the declarations were described to dispatcher Carolina Calvin what they were perceiving. Present sense impression. Those statements relate to Kernodle being passed out and not waking up. The declarations were made immediately after HJ discovered the body. Then they go into some of the statements were excited utterance. Oh yeah, they saw some man in their house last night. Yeah, as well as heaving, breathing, and crying that can be heard throughout the call. The declarants were responding to a startling occasion. The statement responded, persons being home in the being response to Kernodle might be passed out. All statements made while the declarants are processing what is happening. They note that Judge John Judge has already ruled that 9/11 call is not hearsay, and even if deemed hearsay, the exception is present. They also go on to say the statement made on the 911 call are admissible regardless of whether or not the witness testifies. Present sense impressions and excited utterance are admissible. Clearly, the prosecution wants this 911 call in for the emotion of it, I'm sure, and it will more than likely be played. Now, the judge did also order that the order sealing defendant's notice of filing signed as a notarized affidavit that will remain sealed, and that had related to the autism report that the defense was putting forward. So a lot of breaking news. Now, I was on X last night, and I'll be honest with you, there are some sick people out there. All right. There's zero evidence that these roommates had anything to do with it. Now, whether you think, well, they should have done something, I get it. I think that was maybe my first response is, why didn't somebody call? That's just weird to me. But then you think, you got a house, it's kind of a party house, people coming and going. It's still a little weird. They're freaked out. They don't get any response. Maybe they're not there. I mean, it's just, you can kind of make sense of it, I guess, if you want to. Apparently people were drinking, etc. But there were people on X actually saying that these roommates had some involvement in this case. Now, I just think that is outrageous. I don't think there's anything to support that in any way whatsoever. So, I get it. People look for clicks. We're looking for the truth. That's what we want at the end of the day. Next on the docket, another juror from the Karen Read case has spoken out. Now you may say, Scott, what do we care about a former juror on a case that mistried? Probably little to nothing. I've mentioned this before. I remember one of the first cases I ever tried. I had just gotten out of the military, and I was asked to do a second chair on a case that had mistried. It was a homicide trial, and there was some issue as it relates to the struggle that took place in this house and how this person couldn't have done it because the jacket was all tied up and they were in this struggle. So anyway, in second trial, the other attorney and I kind of focused on that. Now, the first jury made a big deal out of it. The second jury, just really didn't understand why we were making such a big deal about that. So the point is, it just kind of shows you each jury is different. If I win a trial, I don't talk to the jury. If I lose a trial, I don't talk to the jury. They made their decision based upon the evidence they had or did not have. And that's it. And if it mistries, I'm not going to try my case based upon that one because it doesn't matter. All right. Each case is different. And as I've said, the trial always goes much more poorly for the defense second time around. And I think the wheels are starting to come off on the Karen Read case. And I qualify that by saying, I think the prosecution basically blew it the first time through. Anyway, this juror comes forward on the trial where Karen Read stood trial on several charges for the death of her boyfriend, Boston police officer John O'Keefe, who was found dead in the snow after a night of drinking. Now, Miss Read faces the charges of second-degree murder, leaving the scene of a personal injury and death, and manslaughter while operating a vehicle under the influence. A mistrial was declared back on July 1st, and the jury submitted 2 separate notes to the judge indicating that they were hopelessly deadlocked. Now, in the months following the trial, several jurors approached both Read's defense and the prosecution to say that the panel had actually unanimously acquitted Read on the charge of murder and leaving the scene of an accident, and had only been deadlocked on the charge of manslaughter. Unfortunately, they didn't let anybody know. And so this juror, Ronnie Estelano, if I'm pronouncing that name correctly, Estanislao, made a statement on a TV show that we were under the understanding that each charge could not be treated separately. And so we continued to deliberate despite the fact that we had agreed on 2 or more of the counts. I don't think so. Normally, the jury instructions include something. There's multiple charges. You must consider each charge individually. Anyway, Mr. Estelano, who was a paramedic, served on the panel, said most of us felt that she was operating a motor vehicle under the influence of alcohol, and that played into it. However, to some individuals, there was reasonable doubt on the mechanism to which Mr. O'Keefe actually succumbed and died. The juror said that the knowledge of working paramedic called into question some of the testimony from the first responders who say they heard Read saying, "I hit him." I found it interesting that was everybody's kind of remembered situation, when usually in the heat of the moment, you focus on taking care of the patient. That's what I'm saying. One juror says something, other people say, "Oh yeah, good point. Let's go with that one." And if that person's kind of a dominant personality figure on the jury, they can really lead that jury there. Other people may say that's completely credible because as a paramedic, you want to know kind of what went on so that you can treat your individual like, "Oh, I hit him. Okay, we're dealing with blunt force trauma. Maybe there's a head injury, neck injury," right? What one person thinks doesn't necessarily mean how it's going to play out in the next trial. Anyway, the juror said the panel debated for hours about O'Keefe's injuries and whether they were consistent with being hit by a car. Now, the juror also says he believes it may be something else. When he said that, when he was asked to believe if O'Keefe was killed by a vehicle. Anyway, he said the defense failed to convince the jurors of the fact that Read was the victim of a wide-ranging cover-up at the hands of Trooper Michael Proctor. The juror said, "We didn't feel like there was any tampering per se," the juror noted, because of the fact that it didn't seem like there was any appropriate timeline to actually do some tampering. And they get it to the lawn or the scene within that particular time frame. Ultimately, the juror said he blames himself and the rest of the juror for failing to give closure to the case. And he believes that if the jurors had asked whether they should have been considered all the charges independently, the mistrial would have been avoided. He said, "Shame on us." Anyway, Karen Read's trial is scheduled to begin on April 1. I think we got motions hearings again, I think on the 18th. And hopefully we'll get some rulings on the issues relating to candor to the court and if there's going to be any sanctions involved there. Next, Luigi Mangione writes to a fan. That's right. Mr. Mangione has developed quite a following of fans since his arrest for the charges of murdering United Healthcare CEO Brian Thompson, who was fatally shot outside of a hotel in Midtown Manhattan on December 4th. Mangione has pled not guilty, and a specific motive for the killing has not been released, but many have speculated that it's tied to Thompson's role as the head of the insurance company. Anyway, Mangione has written a letter from his prison cell to a mother who made him tear up, as the details are made, as the woman struggles to pay for her daughter's health care. The letter states, "Your letter is the first to make me tear up. I am so sorry for what you and your daughter are so senselessly had to endure." Mangione's letter to Karen was shared with journalist and novelist Ashley Shelby, who published it on her Substack dedicated to the case. Now, the mom, Karen, detailed how her daughter deals with a life-threatening condition, and Karen told her that her daughter requires constant care and medical treatment, and last year costs mounted after she was hospitalized for 60 nights. What she and I went through as a result of insurance calling the shots rather than the doctors is a horrible story, as Karen said. She's improving, but hardly close to her old self. Luigi has a soft side, I guess. Made him tear up. Luigi, there's no crying in prison. Everybody knows that. Quit nagging your husband, ladies. I'm just kidding. I'm kidding. All right. But that's what one man, he basically said, "Quit nagging me." Unfortunately, he had to kill his wife. So police in Wisconsin arrested a 70-year-old man after he allegedly killed his wife before disposing of her body in a cornfield. Please meet Gordon Charles Laxo. He is accused of first-degree murder, intentional homicide, domestic abuse, strangulation, and suffocation, and hiding a corpse in the death of his wife, 68-year-old Mary Lasko, up there in New Richmond, which is apparently in western Wisconsin. Now, police received a call about 1:45 p.m. on Sunday about a possible domestic disturbance at the home. The 911 caller said that Gordon Lasko made concerning statements earlier in the day that he may have harmed his wife. Needless to say, cops go and show up. They go to the home. They found Mr. Lasko there, but not his wife. They also could not reach her phone. A little more than about 2 hours later, officers found Mary Lasko's body on the edge of a cornfield in a rural area. Anyway, the criminal complaint alleges that when the cops made initial contact with Mr. Lasko, he claimed his wife rambled at him for 7 hours and then started hitting him. He said things got a little bit out of hand and he didn't know what else to say to the police. Anyway, Mr. Lasko additionally stated he knew his wife was dead, and instead of taking her to the hospital, he panicked and dumped her body. He then reportedly began packing a suitcase and told police that he was going with them. During a search of the home, the police found some bloody gloves and a couple of firearms. When detectives asked him where she was, he allegedly responded, "Oh, you didn't find her?" Anyway, he reportedly said, "She's dead." Officers took him into custody, where he is being held on a $1 million bond. We talked about this the other day. Firing squads are back. All the cool kids are doing it, ladies and gentlemen. A South Carolina death row inmate who gruesomely killed his ex-girlfriend's parents with a baseball bat in 2001 is scheduled to be executed by firing squad today. Now, Mr. Sigmund said he carried out the brutal slaying because he was angry that the victims, Gladys and David Lark, had been evicted from a trailer that they owned. They were in a separate rooms of their Greenville County home, and Sigmund went back and forth attacking them until they were dead. He then kidnapped his ex-girlfriend, because that's a totally reasonable thing to do. Her name was Rebecca Armstrong, put her in the car, but she jumped out of a moving vehicle, wasn't able to escape. Even though he tried firing at her, he missed. But he said, "My intention was to kill her and then myself." Sigmund said in his confession that was typed out by the detectives after his arrest, he said, "That was my intention all along. If I couldn't have her, I wasn't going to let anybody else have her. And I knew it got to the point where I couldn't have her." Anyway, he also told the juries during his trial that he was obsessed with her. Did I love her? Yes, more than anything else in the world. Now, this is the first execution in the U.S. in 15 years with the firing squad. Like I said, Brad Sigmund, who admitted to kill his girlfriend because his ex-girlfriend refused to get back to him, will be blindfolded and strapped to a chair at about 6 p.m. before the volunteers, armed with rifles about 15 feet away, will fire bullets into his heart. Each of the riflemen will be armed with a .308 caliber Winchester. That ought to take him out for sure. Anyway, the bullet is designed to shatter on impact with something hard, like an inmate's chest, for example, sending fragments to destroy the heart and cause death pretty much immediately. The execution will go ahead if the South Carolina Governor, Henry McMaster, and the South Carolina Attorney General sign off on the execution. Sigmund's lawyer have asked McMaster to commute his sentence to death for life in prison, saying, hey, he's been a model prisoner since he got here, works hard every day to atone for the killings he committed after succumbing to severe mental illness. But no South Carolina governor has granted clemency in the 49 years since the death penalty has been allowed to go forward. Now, Sigmund chose the firing squad method over the electric chair, which he was concerned would cook him alive, or the lethal injection, because it doesn't always work. Anyway, 3 inmates in Utah back in 1977, 96, and 2010 have faced the firing squad in the U.S. since the death penalty was reinstated in 1976. Ronnie Gardner was the last prisoner to be executed by a firing squad in Utah in 2010, and the execution in South Carolina resumed in September when the state, once one of the busiest for executions, ended a 13-year pause in carrying out the death penalty. The pause was caused in part by the state having difficulty obtaining lethal injection drugs after the supply expired, because the pharmaceutical companies were concerned that they would have to disclose that they were the ones that sold the drugs, and it would look bad, I guess. The state legislature then passed a shield law allowing officials to keep lethal injection drug suppliers confidential. 25 executions were carried out in the United States last year. 5 have already been carried out in 2025. Then we have this day in legal history. On March 7th, 1965, 525 civil rights activists began a march from Selma to Montgomery, Alabama. Just outside Selma, heavily armed police and deputies broke up the march with billy clubs and tear gas, injuring 65 people and hospitalizing 17 in the melee that became known as Bloody Sunday. After federal court protection had been secured, 3,200 marchers started out again on March 21st. By the time they reached Montgomery on March 25th, their numbers had grown to 25,000. And finally today, ladies and gentlemen, our dumb criminal of the day. During a verbal confrontation Sunday evening, Shelley Hardwick allegedly picked up a whole watermelon and threw it in the direction of the victim, a 56-year-old man who quickly moved out of the way because of his cat-like skills. Anyway, Miss Hardwick told the police that she threw the watermelon only out of frustration and didn't toss it at her boyfriend's direction, not to mention his cat-like skills. Anyway, when the police arrived at the residence, which is apparently a motel on the Gulf Coast, cops noticed that there was watermelon seeds on the victim's face and clothing. Obviously, splatter from when the watermelon hit the wall that she threw only in frustration and not in his direction because of his cat-like skills. Anyway, Miss Hardwick was arrested for domestic battery, a misdemeanor, spent the night in jail, released on her own recognizance, and the judge says, hey, you can't have any contact with the victim. Also, guess what? Miss Hardwick, not only does she get the fun of going to court and probation and all that stuff, if she's ultimately convicted, she's got to wear an ankle monitor with a scram unit to make sure she's not consuming alcohol. Would you bet? I would bet there was alcohol involved. Anyway, Miss Hardwick, you are a dumb criminal of the day. Food violence is not the answer. Let it go. All right, ladies and gentlemen, now for the big reveal. That's right. The BattlBox has arrived. So let me take out the official CrimeTalk K-bar that I've had since I got out of boot camp in 1988, summer of 1988, and open the box. Let's see what we get. The knife, don't want to freak anybody out. You know, they always get surprised if you think you're going to do something. They'll demonetize you in a heartbeat. All right, let's see what we have in our BattlBox mission today. Ooh, let's see here. This is a Zippo rechargeable hand warmer and power bank. Okay, that's cool. We have a PowerTech Soul LED rechargeable keychain light. I like it. I like it. Not a big keychain guy, but if you have a bag or something, throw it on there. Never know. Maybe we'll give that to the lovely Miss Kristen. Let's see here. What do we got here? Oh, it's another knife. That's right. You can never have enough knives. And since I've been getting these battle boxes, I have more knives than I know what to do with. Nice. Very nice. Let's see what else we've got. This is some sort of medical kit, it looks like, because you got to be prepared. You never know when you're going to need it. Always kind of keep something, maybe throw it in one of the cars. Yep. It's like a first aid kit. Let's see what the description says. It's a MyMedic Sidekick Standard. Has stuff for bleed control, burn care, medications, sport and outdoor injuries, tropical ointments, hydration support, and other shears, gloves, and CPR shield, and more. Wow, look at that. We like that. That's always good. Look. Throw it in the car, throw it in a go bag, put it on the plane. You never know if emergency is going to happen, right? What is this? 50-hour burn survival candle. That's pretty slick. Let's see. When the grid fails, light is one of the first things you'll miss. That's why this 50-hour survival candle is a must-have for power outages, emergency kits, and camp setups. Made from clean-burning soy wax, it produces minimal soot and no toxic fumes. That's always good. We've got a big bag here. Let's see what this is. Comes in like a Ziploc bag. I guess that's pretty nice, so you can keep it maybe waterproof. I don't know about that. What kind of bag is this? Oh, it's like a bag for, let's see what they're saying it's for. Oh, got a little carrying case here. It looks like it is it looks like a bag that you can put like tools in or something. Let's see what the official disclaimer is here. Roaring Fire Gear double-sided removable tool roll bag. A disorganized kit is useless. The Roaring Fire Gear tool roll ensures that your tools, knives, and survival essentials are properly stowed. Easy to find. Double-sided storage compartments keeps your gear organized. But wait, just when you thought that was it, there's more. And finally, what is this? Oh, look at this. This is a storage pouch, complete with a secure place to stash your most critical items. The Rock Gator prize storage pouch is fire resistant and waterproof with an RFID blocking solution to protect your documents, cash, electronics, and other valuables. There you go, ladies and gentlemen. The kit has arrived. The BattlBox has arrived. For whatever it's worth, it's just kind of fun. They don't give them to me. It's a subscription actually somebody got me, but I look forward to it every month. So I figured I might as well share it with you all. All right, that's all we have for you today. Thanks for watching. Have a wonderful weekend. We'll see you next week. And remember, the Constitution matters.